and welcome back to the Everyday Innovation Podcast. I'm Jordan Chadsey, and I am an innovation-obsessed indie hacker and tech founder that loves talking with other entrepreneurs about their creative process and how they innovate. So it's been a little while since I've released a podcast, and to be honest, I know this was said in the other episodes, it was kind of an accidental release, so I wanted to take a little time and get my head clear on how I wanted to release episodes, if I wanted to do solo or involve some other entrepreneurs to speak on innovation. Of course, the latter, it was something I was definitely interested in, but I wanted to do a little bit of a mix of both. So actually, what you'll be hearing today is the first of a group of interviews that I've been doing on Clubhouse as well. So as we're recording these podcasts, we're also in a room on Clubhouse. The first few are in the Women Founders Unite Club on Clubhouse. These are not recordings of Clubhouse itself. Obviously, we wanted to protect the privacy of who is in there, and if there were any questions that were asked that were maybe sensitive, we just wanted to make sure that we were all clear on our end. So I would be recording on my side via an external microphone, and same with the person that I'm interviewing. So this episode is with Laura DiFrancesco. She is a fantastic human being and the founder, CEO of Dean Street Law, where she's also the head legal counsel. She's the CEO of Flourish Westchester in Philadelphia. She's just a fantastic entrepreneur. She's a creator too. So this was a really interesting conversation because she wasn't just coming at it from a legal standpoint. She was also coming at it from a creative standpoint. And this is about protecting your innovation, protecting your creativity, using that protection to create more freedom in what you're doing. And we really got some great questions. Because this is in a Clubhouse room, it's going to be a lot more informal. I'm going to edit around a lot of pieces, not over edit everything. So if something's mentioned a couple of times, bear with us. Maybe it's worth repeating, right? And because we aren't recording the people who are in the room, you will hear kind of a restatement of the question. So if it seems a little awkward for a second where it seems like all of a sudden we're restating something that you didn't hear, we don't have any blank spots that are going to be showing up. So it'll sound like we've gone finishing another question to restating the next. So that's how that's going to work, just so you're aware. But we start off in giving some background and having a conversation at first, me asking some questions of her, not just talking about the legal aspect, but also the creative aspect as well. And we actually, because she's such a great interviewer too, she asked a couple questions to me. So that's, I think, why I chose this one to be first, because it gives some background on why I've kind of moved into this innovation space. And even it being a few weeks old, I feel like I would maybe update my answer a little bit, but that's exactly why this is here. This is to kind of show progress and see over time how a story is being redefined and how I experiment through this, including on this podcast too. You'll be seeing lots and lots of changes here, whether it's an intro in the beginning or the format. I'm trying to really start to push the boundaries coming up soon, but feel my way into it, of course, and hope that you're inspired to feel into your experimentation too, because that's what we need. So before we start again, this is Laura DiFrancesco, and she is the CEO and founder of Dean Street Law. That's mainly what we'll be covering here, and Flourish Westchester, and a great creator and entrepreneur. So I'm excited for you to hear this conversation and take a peek at the show notes, because there are some details on where we have had past conversations for our coffee break lives, which I believe we mentioned in the podcast as well. Thank you so much and enjoy.
Bring me up to date on how you've been doing innovation in your life? I know you've been doing so many different new ways of innovating and really diving deep into your innovation processes. Do you want to share with me what you've been up to?
Yeah, absolutely. So I think a few months ago, there was a lot of information coming out about this kind of age of Aquarius. And it's so funny because I've always felt very connected to that, not only because of like my son being in Aquarius, but just the ideas that come behind what they say is very Aquarian, the innovation piece, technology, kind of manifesting things from like spacey outer world into real life. A lot of it resonated with me, and I'm like, why am I not just diving more deeply into this? It's something I do in my spare time anyway. I tend to go on sites like Product Hunt and look on indie hackers, other types of places where people are just creating all the time and creating new products. What kind of transpired is this wanting to get into experimentation and studying innovation and how people innovate in their companies sometimes, but also just in their everyday lives. So that kind of everyday innovation name came from not just innovation in the everyday, it could be disruptive, non-disruptive, but just how we can incorporate that sort of mindset and way of experimental type of thinking and living in everyday life. So I thought, why not, just because of everything kind of shifting, focus on that for a little while. So it's kind of part experimental, part a learning process for me too. And having these types of conversations where we can go kind of beyond just giving some tips and tricks and kind of go into how people think, right? So that's kind of where I'm
Mhm.
at.
I love that. This is fascinating. So, for background, for everybody who's not connected with Jordan and I connected way, way back when we were first getting to know each other through Girl Boss, and we met up at the Girl Boss event in California. And you were so fantastic. I feel like you were such a good host, like telling me about LA and California and everything, and sharing with me your favorite spots. We had so much fun at the Palm Coffee Bar and everything. And we had just like a blossoming friendship and amazing like connection for the entrepreneurship world. I feel like so much of entrepreneurship can be you doing it alone. And even when you have a team, sometimes it's not quite the same as having somebody who's in it with you. So I've really loved our relationship and friendship as having like two like girl bosses in the thick of it, kind of experimenting, doing their own things, coming together, sharing wisdom. And we had a really fun series that we did, Coffee Break Live, for a long time on Instagram. And we still have so much fantastic footage from that I absolutely love. So I'm excited that we're doing the podcast and Clubhouse as well today to share some really cool, interesting tidbits about intellectual property and innovation. I'm so excited to hear about your perspective on innovation because I loved your deep dive into it on how you're talking about astrology and systems and everything like that, and coming from different worlds. And I think there's so much sometimes there's a divide between astrology and lifestyle and what some people say is woo woo, and then business and systems. And I think there's such a beautiful way to marry all of these things together and create so much synchronicities and synergistics that like catapult you forward.
What's really interesting is I had this conversation with one of my really, really good friends. We were talking about what kind of draws us to, astrology or other systems. It can be kind of interchangeable. It's not necessarily that I'm like, oh my gosh, it needs to be, a lot of this needs to tie to astrology or other pieces. It's just, I feel very connected to systems and creative systems. And that is an ancient system that people, follow, or even if you're following the moon, other things, these are kind of these natural systems that come up and that you can kind of play with and toy with and see what works for you. And that's what's so interesting about things like human design or things, that you find in mindset books or something from Tony Robbins. It's like you take these pieces of wisdom, throughout the world, these productivity books, anything that you want, and really kind of design something for yourself. So if it resonates with you, I feel that it's something that's meant for you to at least experiment with and be inspired by. So that was for me something that kind of sparked a lot of the deeper dive into these pieces because it felt like it resonated. So I'm always inspired by the world around me, taking pieces from that. And I wanted to ask you, because you're such a creative yourself in your own right, how do you, because you also are a lawyer, are there pieces of kind of your legal experience that inform your creativity, just the way you think? Because I always think of a lot of business people and doctors think more diagnostically, but as a lawyer, you almost have to think kind of from the forward, then working backwards to build up to that. So I'm very curious about how, before we get into the IP stuff, how you create and if kind of that legal background has informed that for you.
Yeah, there's a couple of really cool aspects in terms of knowledge of how to create in the best legally protective way for yourself and your creative assets that you're creating. And then there's also a component of just like mind structure. So when people pay for law school, so many people say, like, you're not paying for law school, you're paying for a new way of thinking. And that's similar to like the design thinking, right? It is analytical and it is problem solving and engineering in a sense, but law is also just very research oriented. And so it's this knowledge, just deep knowing that there is an answer out there somewhere for what you're looking for. And whether it's through experimentation or research or whatever it is, it gives you law, and the practice of law gives you this tremendous drive to find answers to whatever you're looking for. And that's so much a part of the innovation and creation process is exploration of your ideas. And so I definitely think forward. And I feel like when I have an idea, I'm thinking of, like 10 steps out from where it is and the projection of it and how it's going to come to fruition and like seeing it and all of the problems that arise from it and all of the solutions that come with it, and then building backwards from there, like you said, to really like develop it out and bring it to fruition through action. So it's a lot of like constant problem solution, but experimentation and problem solution are at the heartbed of innovation, and that is actually something that's really consistent, woven throughout the legal practice as well.
I love that. I love that answer because I think, as we kind of jump into a lot of this, I think people feel that if you're in law, if you're in accounting, if you're in a lot of these professional roles, it seems that like you're very niched into what you're doing, right? And that's not necessarily true. It is a way of thinking. Even I've learned going back to school and learning software development. I think the biggest thing that I learned from that was a new way of thinking. It was a way of breaking things down into step-by-step pieces because I don't know what they're saying out there, but computers are smart, but they're not that smart. You got to tell them what to do. So they can do AI, but you got to give them the logic first. So breaking it down, I think they used to say you have to tell it to make a peanut butter and jelly sandwich. It's literally, do 3 swipes of the knife in the peanut butter kind of thinking where you have to really, really break it down into tiny steps. And so I think that when you approach the world in that way, you're learning, you're practicing how to think. I think that it's so important to not only cultivate that, but then of course to protect that, because a lot of the way that you think comes through education, through experience, life experience that kind of really is uniquely you. And I think that we underestimate the types of things that we can protect, the types of things that we actually cultivate by protecting it. So I'm very curious as to maybe what you're thinking. Are there some misconceptions of what you can protect or not protect as either a startup owner or a creator? You can come from whatever angle you'd like, but I know a lot of us probably, including myself, maybe aren't really aware of the types of things maybe we can or should be protecting.
hmm Yeah, there's so much that you can protect. And I think that generally startups and entrepreneurs are thinking of the mind of how to get something to market, how to share information quickly. Like they're actually thinking of how can I exploit this idea? How can I get it out into the world as soon as possible? And when you jump forward that far, which is wonderful, like we're all go-getters and we're all doers, and that really provides the engine of energy that we have in creating our visions and bringing them to life and creating our companies and growing them. But if you don't take the intermediary steps to protect yourself along the way, you risk tremendous exposure in thousands, hundreds of thousands of dollars of costs in legal mistakes when you're not protecting yourself from the outset. But you're also risking just like the loss of your idea, which is sometimes even more painful than the loss of like finances, as much as painful as that is. So as you're thinking through bringing an idea to life, one of the first things you're thinking about is, first off, do you even have the right to use that idea? And I think so often we think because we came up with it that we have the right to use that idea, but that's just not simply true. There are so many wonderful aspects of creation that flourish from one area of the world to another, and people are simultaneously coming up with the same ideas, maybe executed slightly differently. But just because you've thought of it doesn't mean that it hasn't been thought of before. And so something really important to do as you're coming up with your ideas, and even to test the marketability and viability of your idea, is to do initial research, especially in your naming conventions, or if you have a particular design or something like that, do your Google researches, do your US Patent and Trademark Office researches, or your copyright researches, and make sure that you have the right to name something, whatever you're naming it, or if it's some sort of design or creation, that you have the right to, patent it, that it's not infringing on someone else's idea or patent or something like that. So doing that initial test to make sure that you have the right to pursue it is going to protect you from liability, from getting sued, which will, put you underground pretty quickly. So it's something that you want to avoid. And also it impacts the marketability. If you have confusion of name, it's obviously going to hurt your business. If you have confusion, if there's other people doing the exact same thing and you don't realize that, that's a lack of market research. And you're not going to be able to come to the market with something unique and prepared to be able to sell it.
So coming from, my particular background, I was in the music industry. So we dealt with a lot of copyright, infringement versus, the other creations of writing. So you had like kind of the publishing side, you had the recording side. And then I had done some formulations as well. So that's kind of a physical product formulation. But I know that a lot of people are working in tech, and there's a lot of open source collective knowledge that's out there, and it's kind of been not poo-pooed, but like I feel like for entrepreneurs and for the tech world, it's kind of like an idea is not enough to protect, or an idea is maybe not worth it yet because you haven't executed it. So it's kind of fair game. So I kind of want to see what your thoughts are on that, because I think there's some times where maybe that's true and that's okay. And it's, good to be able to share ideas and product concepts and, test that product market fit before even taking it to market, right? And getting feedback from others. But at the same time, we want to make sure that when we are kind of innovating in these new spaces, that exactly right, that something isn't taken or you're not taken advantage of for your willingness to be open and share. So I'm curious to hear your thoughts on that particular area from, when you're working kind of in that tech, more collective knowledge sort of space. I just want to see what your opinions are there.
Absolutely. And there's a lot in the developmental stage that goes before market. But for me, it's really a financial analysis. And I know that a lot of people are of a collaborative spirit, but really when you're operating your business and doing it from a legally protective stance, you want to do it as if worst case scenario. And that's just the lawyer's job to think of worst case scenario and how to protect you and in that instance. Like for instance, Facebook, and this is like a little bit of an ownership issue, right? But like there was disputes around the ownership of Facebook and the software and everything like that. And so for me, it's the investment that you're looking to make and the viability. Like, are you having fun creating a hobby? Are you making a business that you're going to plan on pitching? Because if you're planning on pitching something, investors want to make sure that they know that they're protected, and that they're putting their money to good use. So for instance, if it's something like a name, you can wait until it goes to market. If you have a very I'll talk about some ways to protect before you go to market. But let me start with how to protect before you go to market. So how do you protect before you go to market as you're in this collaborative developmental stage is wanting to make sure that the intellectual property creators are transferring the intellectual property to the appropriate entity if it is a company or something like that. So when you have designers creating code, when you have people on your team who are creating any intellectual assets for your business, you want to make sure that you have the transfer of those rights to the business, because by default they remain the owners of the asset and the intellectual property. So making sure that you have the transfer of intellectual property rights and that you have that flowing properly is really important. And then non-disclosure agreements and non-competition agreements and non-solicitation agreements are really important as well. So making sure whoever's on your team is not going to be taking whatever you're creating and competing is one thing. Making sure they're not using customer lists or vendor lists or code that you're developing or anything like that, and using it against you in a non-competition provision and a confidentiality provision and non-solicitation provision will protect you from losing assets that you're developing. A lot of people, even if they're not putting money behind it yet, even if they do plan to in the future, or they plan to raise capital, or find investors or sell it or something, need to make sure that they're taking these initial precautionary steps, because this will protect you from losing your business from the outset, which is a horrible idea, whether you're putting in time or money or anything like that. And so you want to make sure that you have those non-disclosure agreements, those non-competition agreements, and non-solicitation provisions in agreements, as well as having the transfer of intellectual property. And then the other thing is keeping your team small. So when there is a use of open source and coding and everything like that, but when you're sharing proprietary knowledge, whether that's code or systems or ideas, you are just opening the potential for risk of losing that idea, of having it being taken and changed in a small way and becoming a competitor or something like that. So, of course, having those contracts in place to make sure that you are properly protecting this idea while it's in the development phase, but then also making sure that you are being smart about who has access to this information, because sometimes your greatest assets are trade secrets, which are secrets proprietary to your business that no one else has knowledge to. And that could be a ingredient list and recipe for a product, or it could be code, or it could be systems or processes, or whatever secret is proprietary to your business is a trade secret only if it's not public. And so that means making sure that you have non-disclosure agreements in place so that it's clear that it's not public information just because it's shared with one person, but also keeping the people that know that trade secret very small to a must-need level. And a lot of people are pretty open in terms of collaboration, but when you do that, you really open up the risk in so many ways to lose the proprietary aspects of your ideas, because you are, if they're part of public knowledge, then you lose the confidentiality aspect of those ideas, and you'll lose the treatment as a trade secret.
I absolutely love the analogy to recipes. First of all, not just because I have Macro Kitchen, and that is a tech product that also includes recipes that we had to work through a lot of questions about. We had a lot of content creators where we were attaching, and we were attaching these recipes to our site, but we were really acting more as a search engine with a proprietary algorithm, as opposed to we were the recipe creators. We were trying to kind of position ourselves in a way where we're not really charging or anything for the recipes themselves. It's really kind of how you find them, right? Looking for them in ways where you are able to do it with finding things within certain macros, or including ones with certain ingredients or not with certain ingredients, or filtering by different criteria. So, and then of course, linking back to the original sources, they're acting kind of recipe cards. But that was something that we had to think about as well. But in the more general sense of kind of the recipe itself, you think about like the secret formulas for Coca-Cola, or you think about, the kind of what is the secret sauce that's there, and that's where you really want to limit it. And from the tech perspective, I just some advice for other people, and you can add to this as well if you found some good products to do this. But having, investing in those kind of like G Suite teams where you have your own email addresses and you have a core area where I know that the drives for the workspace, I think it's called, instead of G Suite, it's now Workspace. You have your own dedicated area for your company, and there's no actual downloads to your computer. It's a mirror, just like GitHub would be for code, where you're able to access that information, but you're not directly downloading it to share with others. So having, those types of technologies, using certain things like, I know it's more of a gray area, but some of the messengers that are a little bit more protected are so important in helping to, even if you have a small team, keep it as central as possible. And absolutely having those agreements in place and are so important to make sure that everybody's, not just that you're protecting yourself, but they're also on the same page too with what their requirements are or what they can or cannot disclose. Because I think sometimes people also, if they're excited, might disclose things that they're doing at work, right? And you could put yourself, in a position that's tough, especially if you're pre-market or pre-investment, where you could open yourself up. I do have a quick question though, and we can get into maybe a couple aftermarket things, but this may transition well into that. But let's say your company, and this is something that I personally have a question about, if you're crowdfunding, and it's something that maybe you're not sharing the full secret sauce, but there is quite a bit of an idea that you have to disclose when you're not crowdsourcing, but crowdfunding. It can be a little bit of a gray area for people. While it's a great way to show product market fit, it may provide some issues in the future for investment. So I wanted to get your opinion on that, because I think that's been a common question that I've seen.
Yeah, there are so many benefits of crowdsourcing and crowdfunding. So, in terms of thinking about intellectual property protections, if you are crowdfunding, that's at market. So even though you're not selling the product necessarily, usually it depends on what you're doing in terms of crowdfunding, because there are many different types of crowdfunding. Sometimes crowdfunding, you get stock, sometimes you get debt, sometimes you get products. Assuming that you are getting products or anything like that, that is something where it's at market. But essentially, at any point that you're now changing from internal facing to sharing the idea external facing, it needs to be protected, because it's now out in the common universe and language world of information. And so it's really up for grabs for anybody. And I don't really believe that an idea is not good enough to protect, because that's just not true at all. You have the right to protect your intellectual property, any idea at the idea stage, and some protection costs literally a couple $100. If you're talking about patents or something like that, that's going to cost 10,000 plus. But if you're talking about protecting copyrights, protecting trademarks, getting contracts in place to protect your business, all of those are in the less than $1,000 range generally. If you're trying to DIY it. Of course, if you have someone doing all of this them for you, that's going to be an additional expense. But that's all at market. Your information is now becoming public, and when you share it with anyone basically besides people who are contractually required to not share it, it becomes public knowledge. And so that's the point, that you really want to make sure that you're taking steps to protect your ideas and making sure that it is viable, because you're right, as you bring on investors, they're not going to want to invest in something that's not protected. If you, even something as simple as Shark Tank, if you listen to Shark Tank, they're going to ask, do you have a patent? Do you have a patent pending? That's the first question that investors are going to ask. They're going to, even if they're going to talk to you and they're not going to be that upfront, if they have any sort of interest, they're going to be doing their legal due diligence and making sure that they can acquire all of the rights. If they can't acquire the rights because you don't have contracts in place with the creators of the intellectual property, transferring it to the business, or because it's been shared openly and hasn't been protected from the start, they're not going to value it at the best value if they're going to be interested in pursuing the idea at all. And so when you're talking about, Jordan, you had mentioned sort of like getting investors leery of investing. Another thing to be leery of as you're thinking of crowdsourcing is whether you're giving up equity in your company and whether you're creating debt for your company. Because if you're looking to move on beyond crowdsourcing, those are, of course, two really big components that investors are going to be looking at. And crowdsourcing tends to either be raising it via either exchange of product or some sort of benefit for founders benefits or early adopters benefits, or debt or equity.
Also really great for growth if you already have a base of people that it is public knowledge, it's out in the world, but taking it to that next phase, I feel like crowdfunding is such a great option. But there's so many different ways that you can approach this, but I think your statement is right. You really do have to be mindful, be careful, and especially if you're going to be raising money from investors, you want to at least portray that quality and they'd rather have you be a little bit more cautious. In this area, you can, basically it's kind of like the more cautious you are in this area, but then you're pushing the limits in your creativity, that's where you can really shine, because you have that beautiful dichotomy of like knowing where those limits are and making sure that you protect everything that is being designed and the vision for the future, but then at the same time, not limiting yourself in so many restrictions in the actual creation process. So I think that's so important.
Yeah. So, I mean, I completely agree with you. You're so right. Being able to handle both the business protection and growing the business vision and viability and scalability, plus being able to really execute on product creation, design, innovation, all those things, that is like the gold unicorn that investors are looking for, that the marketplace is looking for. Like, that is the value of your company. And so many people don't realize that it really takes both. You really have to be very mindful of protecting your company and at the same time, really pushing the boundaries of innovation, because that's really where the sweet spot is for becoming a unicorn in the market and really growing and scaling your business. You can't scale your business if you don't have a business, or if it's tied up in, litigation because you've infringed on someone's intellectual property rights, or someone stealing your intellectual property and you don't have any recourse. So that is like the Apple, right? Like, that's Steve Jobs and Apple. Believe me, they were pushing the envelope of innovation, and they also made sure that they were talking to their lawyers and that they were protecting those ideas from the outset, protecting them through contracts, protecting them through who had access to what information, and protecting them, of course, for also filing, making sure that trade secrets keep secret, and they're only only 1 to 2 people have access to trade secrets, if it is that important to the viability of your business, it really should not go beyond 2 people. If it even goes beyond one person, or you should have such a system set up in place that it doesn't have life beyond those people. And that's of course through contracts, but also through processes and systems, like you mentioned, having a specific business space for documents and not having download capabilities, and having the ability to control documents and messages and emails and all that kind of stuff. But then also, when you get to, we've talked about the common mistakes for pre-launch, but I want to get into the common mistakes for launching once you do become public. And so you can file things like trademarks and copyrights pre-sales. So before you're actually selling it, before you're actually selling to the market, or you can register for those post sales. So it is a little bit more expensive to register before your product is at market, or before your idea is at market, or whatever it is. The name is at market, and that'll cost a little bit more. I generally recommend, it just depends on what you're looking for the vision of your business, right? Like if you're looking to be a solopreneur for the rest of your life, and you're not worried about selling to venture capital, and you're not worried about getting outside investors and whatnot, then you can file when your idea is at market. I like to do it almost immediately before, but it just really depends on how much publicity there is behind your idea. If it's really in a small, you're lightly testing it, like almost like a soft opening, and you're really just sharing it with like a close group of people, or something like that, your idea is protected just by you being the author. The benefit of all of these filings, like, you have intrinsic rights to everything that you create, presuming that it doesn't infringe on someone else's intellectual property rights. But the benefit that you get when you create filings that you file with the U.S. Patent and Trademark Office or the U.S. Copyright Office is that you put other people on notice that it's your idea and you own it, and you receive the presumption that if there is a dispute, you are correct and you are the owner. So it provides a tremendous amount of protection. So because you have the idea and you have ownership and rights to it just by you being the creator, presuming, of course, that you have all of those contracts in place to show the transfer of intellectual property rights from the creator to the business. If you specifically aren't the creator, or you, the business, aren't the creator, assuming that you have those in place, you do have intrinsic rights. So I give people like a breather of a couple months, usually once something goes to market, to file it. But that's really for small businesses. If you're looking to pitch to venture capital, if you're looking to bring on investors, I would file right away. It's going to show that you know your stuff. I would file pre-market. You're going to be protected before anything goes public. It's going to show your investors that you're serious. It's going to show them that you know your stuff, and it's going to make them feel good because they know that the second that idea became public, it was already protected. And that is gold. Like, that is so, so important, because there was no lapse of time in which it went from private idea to public idea without protection. It's like coming out of the gates with all your armor on, versus, like, imagine you have a castle and imagine your idea is like riding out on a horse, and it's coming into a front of like lines and lines and lines of people, ready to claim this idea. And if you're coming out of the gate protected, your investors are going to feel good. You're going to feel better, and there's not going to be a gap of time in which there's a lack of protection to create a potential liability, because that potential liability might not surface at first. It might surface years later. It depends on the statute of limitations and the laws for when someone can sue you, or when someone can take action. You might not discover it at first, right? So what they're concerned about is if there is a gap in that protection, that they might not find out before they invest their money, and they might find out years later, which is not a pretty surprise to receive. So when you come out of the gate with protection and it costs a little bit more, we're talking to the tune of a couple $100, not that much more. You are protected from the outset. And a lot of people don't think about that and think through that whole process.
So I was recently part of a project that was, looking to do a process patent, which are, I know, very, very expensive. And a lot of times that is part of the fundraising process. This is part of the initial seed funding is, also including this process patent. Are there any things? Is there anything that you can do to, for people who are looking into the more of the patent side of it, where it is a bit more expensive, and if you're bootstrapping it, it's going to be a little tough to maybe put that up right away, but you still want protection? Is there anything provisional you can do, or is there something to at least demonstrate that you're intending to do this? I'm curious because I know that can sometimes be a cost barrier early on, and why you might need an investor.
Yeah, so patents are a whole different animal. It's not my area of expertise. They are expensive. So when I'm talking about protecting an idea at the outset versus and it being a couple $100 difference, that's really talking about things like trademarks and copyrights.
Yeah.
When you're getting into patents, you're right. It is $10,000 plus, $15,000 plus to get a patent. I don't specialize in patents. You need a specific patent attorney that is barred with the U.S. Patent Office, and making sure that they have all of those requisite certifications to be able to represent you. So I don't touch patents. I believe there is some sort of intent or provisional patent that you can receive. I don't know the cost differences, but really my advice whenever someone is looking for a patent or patenting an idea is to, one, make sure you talk to a patent attorney, of course, to talk about the potential for that, make sure that there is an existing patent. But really, if you're getting to that level of an idea, you really want to make the decision, are you going into business guns blazing? Are you going into business and really doing business, or are you not? Right? Because it's just it's a part of the startup costs if it's a patentable idea. That you just have to factor in. It's almost as if you are starting up a physical location and you have something like rent. It's a cost that is part of the startup process. Right. So if it's a patentable idea, that patent is part of your startup costs. And I'm all in favor of bootstrapping things, but if you're really looking to get that idea to market and make it successful, that is part of the cost of getting it to market. Now, the other part is not patenting it and having your idea a secret, because sometimes, depends on the lawyer that you have, a good one will tell you this, is that the bad thing about a patent is that it only lasts a certain amount of years and you're sharing your idea with the public. So it becomes a public record exactly how to replicate your idea. The benefit of not patenting it is that it's always private. It's a trade secret. Someone can't steal it unless they come up with it individually themselves. So there's different types of patents that protect you in different ways, that give you more protection, or a more broad protection or a more narrow protection, depending on the type of patent it is. But when you do file a patent, that information and how exactly you did it becomes public knowledge. And after the patent expires, all of that is up for grabs to whoever wants to use your idea in whatever way they can. So that is, one of the best ways to protect a secret is to keep it a secret too.
So I have one more, major question, and then we can either open it up or you can give us a couple of steps that we can take. But I wanted to talk about this piece with you because I think with everything that's happened in this past year, and I know you are a huge example of it too, because you're also a content creator. A lot of founders right now are either in the business of content creation for their sales or their money, or they've put this as, it's not necessarily a side hustle, it's just a new aspect of their business. They're selling courses, they're selling, whatever it is. It could be a guide, it could be a PDF that's an ebook that is an accompaniment to whatever they're working on. And maybe they've either diversified themselves doing that, or this is just another aspect of their business. But I wanted you to touch on, for the content creators out there, who, or maybe they were influencers and are now doing more of the sales piece of content. I wanted to see if there were any special parts that apply to founders in this specific area, or founders looking to expand here, to make sure that they're protected in sharing, any sort of intellectual property when it comes to more of the content side.
Yeah, I love this question. And a lot of people are sharing more and more ideas more freely on social media, but that doesn't mean that it is, not protected. If it's an idea and you share it, it's yours as long as it's not infringing on someone else's intellectual property rights. So you have intrinsic rights to that idea as the creator of the idea, whether you're publishing it on social media or whether you're creating a course around it. If you're looking for a guide, I have a free guide on intellectual property and social media. You can DM me on Instagram and I'd be happy to send it to you. And that really goes over guidance on sharing on social media. Ultimately, it's not your platform. You don't own it. So be very careful about what you do share, because one, you can lose it at any time. And two, it really, a lot of people on social media, whether it's correct legally or not, P.S. it's not to take someone else's content and reuse it, whether that's words they use, photos they use, or any combination, anything like that. I have that whole free guide on social media and intellectual property that really walks you through how to use it to your best advantage and protect yourself in the best way. So you can DM me on Instagram and I'd be happy to send that to you. But you do have rights to it and you can protect it. And when I'm doing anything, I have terms of use on my website that includes the notices that and copyright notices on my website to notify people that is my content that I've created. It is proprietary to me, and how it can be used and how it can't be used. And then I also have terms of use and conditions for all of the programs that I sell. So all digital programs have terms of use connected with them, and they set forth the licensing rights and provisions so that when someone's accessing that content, letting them know what right they have to that content in the future. If they abuse the rights to the content by sharing it in any way, I will revoke their access to that content. So making sure that you have good contracts in place, both on your website, in your email newsletters, you can have your terms of use, making sure that you have copyright protections on them. You can have the copyright notice at the bottom of your websites, at the bottom of your emails, on any materials that you create. I always have them. And then you can also file copyrights for your website as a whole so that anything that's added to it can be copyrighted. And then also, if you have particular materials that you want protected, you can file copyrights, and copyrights are very inexpensive to file. So you can file it every time that you have a new digital product launch and you have new materials that you want to protect, whether that's slides or workbooks or anything like that. So just because you put it out there doesn't mean that you should just accept the fact that other people might take it. It's good to be aware that when you put something out there that other people may take it, but you can trademark names of things. You can copyright ideas. There's so much protections that you can put in place, from the contracts that you have to the filings that you make, and then also to just how you treat your content online. If someone ever takes your content online, I have in my trademark course different cease and desist communications that you can use. You can use something as kind and nice as saying, hey, I love that you love this quote of mine, or I love that you love this. I just want to let you know that this is my proprietary information, and please take it down, something nice and kind. Or you could do something that's a cease and desist letter. So I have different forms of communications that you can use to deliver different messages, because certain communications can be of different varying levels. It's a gray scale. It's not like a guns a-blazing kind of way that you go about like telling everybody that they can't use your stuff. Sometimes you can be really nice and kind, and that gets the message across, and you can then escalate it. If they don't listen the first time, then you can move on to a more stern communication, and then you can move on to something with letterhead and cease and desist letter and all those things.
I love that. I love that you have all of these resources here too. And that's something, kind of before we get to if there are any questions, and feel free, I think you can do the little raise hand thing. This is my first time moderating. So I'm not exactly sure fully how it works, but please feel free to do that because we'd love to take any questions. But Laura, of course, you have all of your resources, which again, plug them at the end so they know exactly where to go. But again, if you're kind of walking through that beginning through launch and slightly post-launch phase, what are like some key things that they can do? Where should they be looking to, first step, where should they be looking to make sure that they're not infringing? And then kind of what are a couple other key steps that just to recap, that founders can do to make sure that they're in the best possible position for launch being protected?
Oh, I love this. Yeah. So your first step is, of course, making sure that you're not infringing on anybody's intellectual property rights. So I really break this down in my trademark course. And I also have the Vault, which is like the Netflix of legal support for your business. It's on-demand videos with legal support, including legal support. So I really break it down there, but quickly to share, you really want to research to make sure that you're not infringing on anyone's intellectual property rights. And so doing a variety of Google searches, US Patent and Trademark Office, or copyright searches, making sure that you search Pinterest, search social media, search anywhere that you can possibly search for your idea, search engines, searching through the Secretary of State websites, if it's the name of your business. So wherever you can possibly search as much as possible. You can also, if you'd like, hire a professional search agency. So if this feels daunting and you're like, I just want to know that I'm good, you can hire a professional agency or an attorney to do the searches for you to make sure that you're good. So that's researching to make sure that you're protecting yourself from infringing on someone else's intellectual property rights. Then immediately you want to make sure that you know who has access to the information, and you're controlling the access to the information. So you can only keep something confidential if you are able to control the access to the information, and who has access to that information. So contracts with those people, like you said, practical things as to like the amount of people who have access to something or the platform on which they have access to something. So really creating an environment for success for yourself. So making sure that you have the contracts in place to transfer the intellectual property rights to the business, to make sure that you have non-disclosure and non-competition and non-solicitation provisions in those agreements with whoever you're working on this project with, and controlling that information. And then as you're thinking of getting to market and post-market, making sure that you're consulting with an attorney on whether the appropriate filings or appropriate strategy is to keep something as a trade secret and keep it as private as possible and not file it, or to file things like a trademark or a patent or a copyright to protect your idea from being taken from others. And then as soon as it goes to market, having those filings in place or being ready to file to protect yourself, and making sure that when you do something outwardly facing, you have those contracts in place to protect you. So whether that's terms and conditions for the sale of your product, or terms of use for something like a digital product, or your website, and making sure that you have everything clear on expectations as it goes to market for the use of your product, because you can even include in the terms of use of your product, that someone's not going to be taking it and reselling it, or, stealing it in any way and using it in any way. And then also making sure that once it is in market, that you are, setting up Google searches and regularly checking. You want to check every couple months to make sure that you're checking those Google searches, checking search engines like Pinterest or whatever it is, and checking U.S. Patent and Trademark Office and Copyright Office to make sure that no one's infringing on your idea. And to continue to maintain those protections, you have to make sure that people aren't infringing on your idea. And if they are, that you have to take action. So part of maintaining the protection for your idea is preventing other people from using it. So sending out those various communications. And I have explained all of this in further detail in my free social media and intellectual property guide. So you can DM me on Instagram if you'd like a copy of that, or you can also you can find a bunch of additional information as well as support for various aspects of your business through the Vault, which is on-demand videos of legal support for your business, as well as the various intellectual property courses that I have. Right now I have a trademark course, and then I'm also creating more as I go, so as requested, as purchased. So if you'd like a copyright course, if you'd like me to break out the communications for the various templates that I have for cease and desist, I'd be happy to do that. You can just DM me on social media at Laura M. DiFrancesco, and I'd be happy to create anything to support you in your business.
So I want to open it up to questions. If anyone has anything in particular that they'd like to ask us, ask Laura about your protections, anything relating to IP.
At what point in your creative process should you trademark? So when you have a name, I'm guessing you're talking about the name of the program. Okay, so when you have a name of a program that's proprietary, one of the first things to do is research to make sure that you have the rights to that name. And you'll need to do that before you're able to file a trademark for the name. So making sure you do a Google search, that you search the U.S. Patent and Trademark Office, that you search social media and everything like that to make sure that you have the rights to the name that you want to trademark. And then presuming that you do have the rights and you are able to trademark it, then of course, as soon as possible is the best case scenario. Sometimes you want to trademark pre-market. That way, you're not investing time and energy and money into building a brand recognition that you'll then have to change, or if in some way, if someone tries to take it, because the benefit of when you are able to file and receive an authorization from the U.S. Patent and Trademark Office for your trademark, when you receive that trademark, then you are protected and you receive the presumption that you have the right to use that trademark. So if you ever have a dispute with someone, you have that right to say to them, I have a trademark. It's been approved by the U.S. Patent and Trademark Office. And it actually shifts the burden of proof to the other party, and they then have to prove that you don't have the right to use it. And that's a tremendous amount of protection that it grants you. So whenever someone's investing in branding, automatically I recommend that they file a trademark. If you're spending a single dollar on branding, whether that's advertising for brand recognition or paying a graphic designer, make sure that you have your trademark done first, because it would be silly to spend money on branding and market and advertising if it's something that you don't have protected. And so if you don't have it protected at that point, then $1 coming in, or the first couple $100 that would pay for the trademark, is what I recommend when people file their trademark. But of course, at this point, you guys have done it 6 times. I would recommend trademarking it immediately as soon as you can, because it's obviously brand recognition and brand name that means a lot to you, that you've spent a lot of money, even if it's not physical dollars, that it's like time and energy and brand equity that you've built into this name. So I would definitely recommend trademarking it as soon as possible. So the question is whether a trademark is beneficial even if you're not willing to go to court to protect it? And absolutely, because when you have a trademark, it creates so much presumption in your favor. It's actually putting you in a better position to not have to sue someone. Because when you have a trademark, it creates that presumption that you already own the rights. It puts the public on notice that you own the rights. And so the likelihood of someone trying to steal it is going to be less because, or, their success in trying to steal it is going to be less because, one, with a trademark, you've already put the world on notice that you own the rights to this idea, this name. And then two, by having the trademark, you can just simply, I have template communication. So I have a trademark course, and then I also have template communications where it ranges from a nice, kind message that says, hi, just wanted to let you know, I'm so glad you love this name, or I'm so glad you love this idea. This is I have this trademarked and it cannot be used by others. Can you please change your name so that it does not infringe on my intellectual property rights? And you can have a really kind communication. And then there's gradual different communication templates that I have that are kind of moving to a more progressive stance and more of a escalating it to a cease and desist letter where it's saying, you've infringed on the intellectual property right. Please cease and desist from using it. Please remove all prior uses of it and redact all, prior issuances of that are using that intellectual property that is infringing on my intellectual property. So by getting a trademark, it puts you in a better position so that you can actually be less confrontational because your position is stronger. So for developing courses, there are a couple different ways that you can protect it. So you would want to trademark the name of the course. So making sure that you research the course name and have the right to actually use the name idea that you've come up with. So that's a really important aspect. You want to search Google, search the US Patent and Trademark Office, search through social media and everything to make sure it's not already being used. And assuming it's not, then definitely trademark it. If you're spending any money in graphic design or building out a website or anything in ad dollars to promote it, I highly recommend that you trademark it before you spend those dollars, or at least apply for the trademark before you spend those dollars. And then if you are not making those investments yet and you're looking to bring in revenue to pay for the trademark, then I recommend doing it just as soon as possible, as soon as you can. And then in addition, you want to have terms of use so that when someone's purchasing the course, it automatically says, do you agree to the terms of use? And then the terms of use will include all the provisions to make sure that your information within the course is proprietary, confidential, and that they don't share it and they don't use it to compete with you in any way. And it also gives them a license to use it. And so if they breach the terms of the license will be revoked. So that protects you as well. And it establishes kind of rules of the roads and expectations between the parties. So that creates a lot of protection from you. And then also, of course, recommend making sure that you include a copyright notice on any course materials, your website, your emails, anything where you have anything in writing that you want to protect. And if it's really important to you to protect certain materials, you can also copyright your website, your course materials, and everything like that pretty inexpensively. Copyrights are very inexpensive. And I have information on this all I have the vault. Well, I have the library for free legal resources. So if you would like those, you can DM me and I'd be happy to send you the link to download those free legal resources. And then I also have the vault, which is on-demand video legal support for your business. And then I have template terms of use and trademark courses and everything like that. So I'd be happy to help you with anything you need.
And also just to pop in, because I know this was asked in a different way, maybe a little bit earlier, but if you need to host any of that stuff too, a lot of the course websites will allow you to do that, especially like if you have your own terms that you would like to do, you can do it through that, or you can use termly.io. You can use custom put together pieces. So let's say you have kind of a template maybe from one of these sites and you want to add something to it, they're very flexible. So Termly.io is a really great company that I've used on my software, but you can use it on any website to help protect that.
That's awesome. I'm so, so proud of you. And I'm so excited because when I hear someone who's protecting their business from the outset, I'm just so excited because it creates such a better situation for you, and it protects you from liability. It protects your assets, protects your business. Just always makes my heart so happy to hear someone who's on top of it. So I'm so proud of you.
We will be doing some more, I'm sure, Clubhouse and on our Instagrams sharing this as well. So please give us a follow. We'll follow you back. We're really friendly. But Laura is fantastic. Do you want to plug anything else? I know you've shared some of those, but Laura does so much. I don't know how she does all the things, but she knows how to protect them. So that's good. So like Laura has the market on every idea. No, I'm kidding.
Thanks. I actually became an attorney so that I can be the best entrepreneur that I can be, because legal is the framework of doing business. It's really like the fabric that holds everything together. So if you're looking for free guides, I have the library. You can DM me on social media at Laura M. DiFrancesco, and I'd be happy to send you those free legal guides. It includes protecting your assets, protecting you and your business. I also have the one on social media and intellectual property. And if you're just getting started, I also have a free guide on the different types of legal entities and which one's the best for you. So I'm also adding to that regularly. So the library is a great resource for that. And then I also have the vault for on-demand legal support. But if you follow me on Clubhouse and if you follow me on social media, I'm constantly sharing more free information, how to support your business. I just shared 5 good tips for supporting your business legally on Instagram, so you can check those out as well.
Absolutely. Make sure to go to Laura's content I love that you call it the Netflix of like legal content, because it's exactly what it is. You need that. Sometimes you just need that on-demand knowledge, and you always set up your content so well, and it's very understandable and walks through the process because you're also an entrepreneur. You know exactly what that process is. So please, please, please go follow Laura and follow me too, and we'll experiment together and we can ask Laura questions when we need to protect something. So I appreciate you guys being here with us today. I really, really do.
Thank you so much. Yeah, follow us on Clubhouse, follow us on social media, and we can't wait to connect with you. And if you're looking for inspiration, Jordan is absolutely incredible for tons of resources on, idea hacking, design hacking, and just like getting your systems and processes and automations in place so that you can spend time on your business, not in your business. But thank you everyone so much for joining us. I hope you have a fantastic day. Jordan, thank you. You did incredible moderating. Hope you all have a wonderful day.